So, have you ever heard of government that says it wants to protect whistleblowers, but then it turns around and prosecutes them? Well, that's exactly what's happening in Australia right now. Okay, so imagine exposing a major wrongdoing by the government agency only to find yourself facing criminal charges. That's the reality of Richard Boyle, and today we're diving deep into this complex and very controversial case. So, we're going to be exploring the topic that raises these serious questions about justice and fairness in Australia. The government's contradictory approach to whistleblower protections. So let's talk about Mr. Boyle, the whistleblower who exposed wrongdoing within the Australian Taxation Office, now finds himself facing criminal charges. So firstly, let's set the scene. Mr. Boyle was an employee of the Australian Tax Office, ATO for short, who blew the whistle on ATO's misuse of garnish orders. These orders were being used to dip into small business accounts and extract debts, effectively squeezing the businesses dry to boost their end-of-year financial figures. So Boyle's actions brought this practice into light, leading multiple inquiries that confirmed that ATO was acting unlawfully. It's clear that Boyle's actions were in the public interest, so why the hell is he being prosecuted? The answer lies in the flaws of the Public Interest and Disclosure Act, or the PID Act. The law was supposed to protect public sector whistleblowers like Boyle, but in reality, it falls far short. According to the South Australian District Court and later Supreme Court, while Boyle was right to expose ATO's misconduct, the evidence he collected to prove his case wasn't protected under this PID Act. This means that even though the law itself obscenely protects whistleblowers from liability, when they disclose these sort of wrongdoings, it doesn't cover the real acts that gather the evidence. The Attorney General Mark, who drafted the PID Act back in 2013, is well aware of the shortcomings. In fact, he even pledged to fix these flaws if re-elected. Despite his promises, he was done to little protect these whistleblowers like Boyle. Instead, dropping the prosecution case, the current Attorney General is pushing forward with the case against Boyle despite the clear indication that the laws are inadequate. Why? Because there remains a mystery. So let's break this down further. Boyle made the public interest disclosure to the ATO on October 12, 2017, after which he went to the Ombudsman and eventually to the press. Under Section 10 of the PID Act, an individual who makes a public interest disclosure is not subject to any civil, criminal, or administrative liability, including disciplinary action, for making this public interest disclosure. However, the court found while Boyle was protected under the blowing of the whistle, he wasn't protected for the actions that took to gather this evidence. So, it's like taking photos of a taxpayer's information, recording the conversations, and sending emails to his lawyer. Here's where the contradiction lies. The law is designed to protect whistleblowers, but its wording is so ambiguous that it falls to cover the very actions that it needs to be proven, this sort of wrongdoing. And it isn't just a theoretical problem. Boyle is now facing 24 criminal charges ranging from minor offences like using a mobile phone to take photos of more serious allegations related to covertly recording conversations. These actions were necessary for Boyle to build his case, yet in the current procedure and the interpretation, it doesn't protect him. So it brings us to the fundamental question. Why is the Australian government prosecuting someone who has clearly acted in the public interest? Well, again, the Attorney General says that he has the power to end this prosecution under Section 71 of the Judiciary Act 1903, which allows the Attorney General to terminate any prosecution. In fact, he actually used his power in a very high-profile case back in 2022. So why doesn't he do the same for Boyle? The lack of this movement, the issue has left many Australians battled and frustrated. When he was in opposition, he actually criticised the coalition government for not implementing the 2016 Moss Report recommendations to reform the PID Act. He promised that if he was elected, he will make the necessary improvements. But now he's in office, he startled on these reforms, seemingly dragging his feet on proving the greater protections for whistleblowers. So we see this in November 2023, where a consultation paper of the second round of the PID Reforms Act were released. It suggested that extending immunities to cover these kind of preparing of the acts, the very action of Boyle took to leading this prosecution. So again, why has this Attorney General invented this sole case if he's considering the law that would ultimately protect someone in Boyle's position? Will the Attorney General ever attempt to overhaul the PID Act in this term? Boyle's case is a classic example of the catch-22 situation. He did the right thing by exposing the wrongdoing, but because the laws weren't drafted clearly enough, he's now facing the possibility of a lifetime in prison. And while his trial has been postponed pending a High Court decision appeal, the fact remains that the Attorney General could end this today. The most really complex part is that the situation that Boyle's trial was set to begin next Monday, but his legal team has now filed special leave to appeal to the High Court. This appeal focused on whether the PID Act should be extended immunity to kind of preparing these material. So if the appeal is successful, it could set a precedent that protects future whistleblowers from similar prosecutions. However, the question remains, why is the government so determined to pursue this case when it clearly contradicts the started position of whistleblower negotiations and protections? What does this mean for whistleblowers in Australia? The current situation suggests that while the government talks about protecting whistleblowers, its actions speak louder than words. The contradiction is not only undermines the credibility of the government, but it also discourages potential whistleblowers from coming forward knowing that they could face severe legal consequences for doing the right thing. So if you are concerned about this issue or need legal advice regarding whistleblowing, it is very crucial that you understand your rights and the current legal landscape. Whistleblowing can be a very courageous act, but it's also fraught with risk, especially under the new legal framework. Thank you for tuning in. I hope you enjoyed this. There is another case that I'll, of course, be speaking about Julian Assange now that he's back home. But if you want any other cases or any other information, leave it in the comments and I'll always come back to you. I'll see you in the next video.